Welcome back to class, and today we'll be discussing on contract law in business. Contract law in business. Contracts are the bedrock of commercial transactions, essential for enforceable agreements and mitigating legal risk. So, this model will cover key principle, essential element, contract type, termination, breach, and remedies. And we will look into evolving rules of e-contracts and digital signatures in international business. A contract, just like I said now, is a legally enforceable agreement between two or more competent parties, creating mutual obligation, and it is formed through a valid offer, acceptance, and consideration with the intention to establish legal relations. And according to Sir Frederick Pollock, now, it defines a contract as a promise or set of promises which the law will enforce. It's a promise or set of promises which the law will enforce. And this actually highlights that only agreements meeting specific legal criteria are enforceable. As such, we have the essential elements of a valid contract, and if these are not in such contract, it is not considered a contract. And these are offer, acceptance, consideration, intention to create legal relation, capacity to contract, legality of purpose, and genuineness of free consent, genuine and free consent. For offer, it's a clear, definite proposal by the offeror expressing willingness to enter a contract under specific term communicated to the offeree. Then we have the acceptance. The acceptance is the unconditional agreement by the offeree to the offer's term communicated to the offeror without modifications. We have the consideration, which is also a major element, which state that sometimes something of legal value exchanged between parties. It is something of legal value that is exchanged between the parties, such as money, goods, services, or a promise to act or refrain from acting. As per the intention to create legal relation, it's actually showing that parties must intend to create a legally binding agreement presumed in commercial dealing. And also, parties must have legal ability to contract minors, mentally incapacitated or intoxicated individual may lack full capacity as such, and that is capacity to contract. And for legality of purpose, the contract purpose must be lawful and genuine and free consent. It shows that consent must be freely given without coercion, undue influence, fraud, misrepresentation, or fundamental mistakes. We have types of contracts. We have the express contract, which deals with terms are explicitly stated verbally or in writing with clear communication of mutual assent. Also, we have the implied contract, which arise from the conduct of circumstances of the parties indicating mutual intent to contract. We have the written contract, and this is a documented writing and signed contract, which provides tangible evidence and often required by law for certain agreements. And lastly, we have the oral contract. The oral contract is a verbal agreement that are legally binding if all contractual requirements are met, though proof can be challenging in this kind of contract. We also have termination and breach breach of contract. For termination of contract, contract can end when obligations are lawfully discharged, and this can be by performance, that is, both parties fully meet their obligations. Also, by agreement, parties mutually agree to end the contract. By frustration, that is, unforeseen events makes performance impossible. And by operation of law, that is, legal conditions like death or bankruptcy. We have the breach of contract. For this, it occurs when one party fails to perform contractual obligations without legal excuse, and this can be material breach or minor breach. For material breach, it is substantial failure undermining the contract essentials, allowing termination and damages. And for minor breach, it's a slight deviation from terms entitling the non-breaching parties to compensation. What are the remedies for breach of contract? Um, as per damages, monetary compensation for losses incurred due to the breaches, including compensatory, consequential, nominal, and liquidated damages. Also, for specific performances, court order compelling the breaching parties to fulfill contractual obligations, typically for unique items where money is inadequate. And for injunction, court order. This is court order to do or refrain from a specific act used when legal remedies are insufficient to prevent irreparable harm. As we know that we are in a contemporary and digital period, in doing business or performing contract, we now have what is called e-contract and digital signatures. When we talk about e-contract, they are legally binding agreements created and executed electronically, offering speed and a cost efficiency. And as per digital signature, it's the use of cryptography to verify authenticity and integrity, enhancing trust in online transactions. And real example of these real-world examples are that of the Amazon eBay transaction, where buyers agree to terms by clicking buy now. And for software licensing, users click I agree for binding license agreement. And for cross border supply, multinational corporation use secure digital platform for contract. The challenges, the legal challenges and risks as per contract are the jurisdictional uncertainty, that is dispute over applicable law in cross-border transaction. And for it also has a challenge as per the authentication, which is the complexity in verifying digital signature identity. It also has a challenge as per the enforceability, that is, not all countries fully recognize electronic signature for all contract type. And there is a challenge as per the cyber security, which is the vulnerability to hacking and data breaching. And lastly, challenge as per consent and clarity, that is ensuring informed consent for e-term. In conclusion, gaining mastery of contract law is crucial for business professionals to create sound agreements, mitigate risk, and navigate disputes in a complex global marketplace. So balancing traditional doctrine with technological advancement is very, very important. So this is what we have to know about contract briefly. Thank you.